this one. Good morning and welcome to oral argument at the 5th District Court of Appeal. Before we begin, let me introduce the panel. My name is Emerson Thompson. I'll be presiding this morning. To my right is Judge Jacqueline Griffin, and to my left is Judge Carrie Evander. Now, we have a visiting judge with us today, Judge Marlene M. Alva. It would be helpful to us if we took the cases out of order. The parties here on David Allen KUKETZ versus ROSALIE BIBONA. If the lawyers are present on that, would you come forward, please? And then we'll go back to the order of the docket. Thank you. This is a civil case. Each side will have 20 minutes. Obviously, if you would like to bifurcate or split your time, you certainly can. If you want me to assist you, just let me know how much time you want. If you have any electronic devices, such as a pager or cell phone, would you shut them off or put them on vibrate so they won't interfere with your colleagues as they address the court? Ma'am, you may begin.
Thank you. Your Honors, my name is Marcia Lippincott, here to represent the appellant David KUKETZ. This is an appeal from a final judgment establishing a constructive trust based upon an unfulfilled promise to marry. The basis for the trial court's judgment is the finding that Mr. KUKETZ promised to marry Ms. BIBONA without ever having the intent to do so. Mr. KUKETZ contends that this finding is not supported by the competent substantial evidence. First, it's important to note that the only direct evidence regarding this matter is Mr. KUKETZ's testimony that he did intend to marry Ms. BIBONA. She didn't dispute this testimony. In fact, she testified that she had no doubt that they were getting married. And in addition, she admitted that Mr. KUKETZ was always very candid with her about his feelings and concerns about the relationship. Now, Ms. BIBONA listed 21 points she claims provides the evidence necessary to sustain this conclusion. But an examination of these elements, these 21 points, proves Mr. KUKETZ's contention, and that is, there is no sufficient evidence to support the conclusion reached by the trial court judge. First, 9 of the 21 items that she raises takes place after the Christmas of 2000 engagement and after the August 2002 refinancing of the mortgage on the property in question. And it should be quite obvious that the events occurring after these times have nothing to do with showing a prior alleged lack of intent. Now, 3 of the items are simply facts having to do with Ms. BIBONA's acquisition of the house and its refinancing. Yes, there's no question but that she paid the down payment, she made improvements. There's no question about that. But these facts have nothing to do with whether Mr. KUKETZ did or did not have an intent to marry Ms. BIBONA, and they establish nothing regarding the challenged issue. 4 of the items concern Mr. KUKETZ's anxiety about getting married and the couple's pursuit of counseling. But again, this anxiety and the pursuit of counseling do not support any reasonable inference that he never intended to marry Ms. BIBONA. Rather, these facts suggest the opposite. These facts suggest his honesty in acknowledging the problems and a desire to dissolve those problems to achieve the marriage goal. 4 of the items are inaccurately reported in Ms. BIBONA's brief. Mr. KUKETZ did admit to a relationship with a woman in Oregon at some time between 96 and 98, but neither he nor anyone else testified that this was a secret. Indeed, he testified that Ms. BIBONA knew about the relationship, and she did not deny that. Moreover, the fact of whatever this relationship was, and that's not defined, it has no bearing on his intent to marry in Christmas of 2000 when he proposed, or in August of 2002 when she refinanced. The second item that was misstated is that Mr. KUKETZ does admit to enrolling in Match.com for 1 month in December of 2001. Again, this was no secret to Ms. BIBONA. She's not testified to the contrary. And there's no evidence that this 1 month enrollment produced even one date, much less there's no evidence that this brief enrollment in Match.com certainly doesn't support the inference that he never had the intent to marry. Then there's Mr. James Davis's comment. He testified that in July or August of 2002, Mr. KUKETZ said to him that Ms. BIBONA doesn't know this, but things between her and I are coming to a head. But he admitted in cross-examination that these two people were arguing on that day, they were having a quarrel, and that Mr. Davis didn't know whether this coming to a head remark had to do with the subject matter of the quarrel or something else. He just drew his own
Can you briefly state why the judge imposed a trust, the reasoning why the judge felt a trust was the best way in this paternity suit to equally divide the property or secure the support of the minor child or residence for the minor child?
Yes, Your Honor. The constructive trust was imposed pursuant to the trial judge's explanation or judgment based upon this finding that Mr. KUKETZ never had the intent to marry. She explained that in her judgment. That's why she was ruling the way she did. Our contention is that there is not sufficient competent evidence to support that conclusion.
Well, factually, isn't the record clear that she made the substantial deposit to buy the home, she did the closing, and she paid the majority of the obligations of the home, including the mortgage interest and so forth? Is that reflected in the record accurately?
It's certainly true, Your Honor, that she provided the down payment and that, she bought this house initially on her own. There's no question about that. There's no question that she put substantial monies into it. But there's also no question that beginning in 1997, Mr. KUKETZ also put substantial monies into it. In fact, her own pleadings that show that over this period of time, he put over $75,000 into the home. So this is really a situation like the Biondi case. It is true. If you look at Exhibit 14A, 14 and 14A, Ms. BIBONA's own pleadings, it shows how much money he put in. And yes, it is true. It's over $75,000. That's a lot of money. That's significant. While Ms. BIBONA's share may have been more, that still doesn't take away from the fact that they both put money into this, nor does it take away from the fact that the judge imposed this trust, took away Mr. KUKETZ's interest, but that he is still liable on this mortgage.
Well, let me ask you this. Even if one event may not support the inference that your client did not have the intent to be married, what about the timing of several events? You have in November where he wants to delay the marriage. Then later in November, he sends a letter that he wants half interest in the house, less we're getting credit for $40,000, followed by a conversation the following June or July in which Mr. Davis takes your client's statement to mean that the relationship's going to end, then August refinancing, and then later in the fall another postponement of the marriage date. Now, if you put those all together, is that supportive of the trial judge's conclusion?
Certainly not, Your Honor. None of those things speak to Mr. KUKETZ's intent at the time of the engagement or the August 2002 refinancing. None of those even...
Well, in fraud cases, it's very rare where a litigant will get up and say, yes, at the time I made this statement, I had no intent to carry it out. Pretty much all fraud cases the trial judges see involve the use of circumstantial evidence and other facts.
Certainly. And our contention here is we don't have enough of those circumstances, Your Honor. It is very, very, very weak.
What's the burden of proof here?
clear and convincing evidence. For constructive trust, it's clear and convincing evidence. And we certainly just simply do not have that.
Well, didn't the judge consider his relationship with another woman, the fact that he indicated he was not going to be married, stayed in the residential home, and continued this meretricious relationship with this woman outside of the home?
Well, Your Honor, you're talking about events that took place in 2005.
I understand that, but
how can that possibly...
I understand, but the fact that he's searching online for a soulmate, that he evidently found one, can't the judge look at the totality of the circumstances and see that he had no intentions of marrying? Plus, when you look at his potential to earn income and the income he was earning, the declining income, the judge might reasonably suspect that he was taking advantage of this woman while engaged in other activities or seeking people to engage in other activities.
Your Honor, absolutely not. I completely disagree. What happened in 2005 has absolutely no bearing on his intent.
But doesn't it indicate his mental attitude toward this relationship? Doesn't it indicate his attitude toward this relationship?
No, Your Honor, people change. I mean, let's look at I think what is most important are the circumstances when these parties got engaged and when they refinanced. Mr. KUKETZ gave Ms. BIBONA a very valuable wedding ring, engagement ring, $7,500. He is the one who asked for and pursued counseling actively. You know, these aren't the acts of somebody who intends to rob this woman, which is basically what the trial court judge found. In addition, look at Ms. BIBONA's own testimony that Mr. KUKETZ was very candid and honest with her about his feelings and doubts. He wasn't trying to pull the wool over her eyes. That was her own testimony. How do we get away from that? You know, how do we escape her own admissions that he was very candid and honest with her about her feelings? If we look at the totality of the evidence here, however you add it up, it's simply not enough to establish clear and convincing evidence of a lack of intent to marry at the critical times we're talking about. Secondly, if we look again at the final judgment and the language of the trial court judge, we see that she also stated that the parties enjoyed a confidential relationship. And she says, relying upon the Supporta case, that a presumption arises that a transfer of properties between them is a result of undue influence. And that's not what Supporta says. It's not a correct statement of law. A correct statement of law can be found in the Mulata case, and that is where a deed can only be set aside on the grounds of undue influence if the contesting party shows that the will of the grantor was overcome, depriving the grantor of free agency. And the law raises that presumption of undue influence only if there was a confidential relationship between the grantor and the beneficiary the beneficiary actively procured the instrument granting the gift. First off, there was no gift in this situation.
Well, Mulata doesn't say that it has to be a gift. I mean, the facts in that case was that it was a gift, and they made that statement. But I looked at Mulata. I don't think anywhere it says in there that a gift is required. They were just referencing the facts in that case.
Well, I don't think you can find another case involving this statement of law where you don't have a gift involved.
Okay, but would you agree that Mulata did not say that a gift was an element in there? I mean, it just is referencing
a gift
facts.
was involved with that,
right?
So that's true. But again, I would suggest that you won't find another case discussing this principle where a gift is not involved. Moreover, we simply don't have active procurement in this case. Active procurement means being involved in the mechanics of the transfer. Drafting the deed, getting the notaries, doing all those kinds of things. We have none of that here. It's completely absent. We don't have that. Those are necessary facts to make that conclusion. In short, there's simply no basis in the law or the facts of this case to support a judgment for constructive trust. The correct solution has always been partition. Petition is a proper remedy for property co-owners whose relationship terminates and who have made unequal contributions towards the property. All that's taken consideration in partition. As it stands now, the trial court has divested Mr. KUKETZ from his interest in the real property, but has left him legally obligated on the note and mortgage, and has left his credit burdened by this obligation. And certainly the rescission of any instrument always requires that the parties be restored to the status quo. At the very least here, Ms. BIBONA should have been required to refinance that mortgage, relieve Mr. KUKETZ of that obligation, and leave that burden on his credit. And if for any reason that wasn't possible, then Mr. KUKETZ should not have been divested of his interest in the property. It should also be noted that Ms. BIBONA concedes here that the trial court did err in reserving jurisdiction in the final judgment for an award of attorney's fees, and she agrees that that should be stricken from the judgment. See, I have about 5 minutes remaining. I'd like to reserve that time for rebuttal. Thank you.
Good morning, Your Honors. May it please the Court, my name is Marshall Morgan, and together with my co-counsel, Norman Levin, we represent the appellee, Ms. ROSALIE BIBONA, in this case. Your Honors, this case is really much simpler than I think the briefs have led on. What we're dealing with here is a classic case of constructive trust, whereby the elements that need to be shown are a confidential relationship, transfer of a property in reliance on a promise express or implied, and then there must be some unjust enrichment. Your Honor, the record is replete in this case with competent and substantial evidence to support each of the elements of the 4 elements for constructive trust. Let's take a look at the final judgment.
But before you do that,
yes, sir.
Let me ask you about burden of proof. When you started the trial, what was your burden of proof?
The burden of proof to demonstrate constructive trust is clear and convincing evidence.
Okay. Now, so that would be for each of the elements that you had to prove by clear and convincing evidence?
Yes.
And actually, constructive trust is a remedy. Would you agree with that?
It is a remedy, yes, Your Honor.
All right. So what you're really trying to prove is either fraud or undue influence.
Or abusive confidence, sure.
What about the judge's language in the order? Because of a confidential relationship between the parties, a presumption arises that a transfer of real property interest between them is a result of undue influence. Now, does that suggest that the trial judge felt that once you established there was a confidential relationship, that the burden then switched to the father here to show that the gift was not, or the conveyance was not proper? I mean, did the judge switch the burden of proof with that statement?
No, I don't think that the judge did that in this case, Your Honor. It's really hard to tell from the language of the order, but you can see that in responding to that, you're hinting at whether they shift the entire burden of proof or whether it's simply shifting the burden to put forth a reasonable explanation. In this particular case, as the judgment itself notes, the appellant did not put forth any reasonable explanation at all. So based on that very language in the final judgment, you can assume that he didn't even meet the weaker burden, which is just to put forth a reasonable explanation.
But wasn't his explanation, I did intend to marry her at the time, but then I changed my mind?
Well, I think it's tied, Your Honor, together with the confidential relationship, the fact that the entire premise of the conveyance was based on the very near plans to marry and to make the home, the house, the family marital home. So I don't think that in this case the judge misappropriated the burden. I think that in this case the judge appropriately demonstrated that there was simply no explanation, which is, in fact, the lower burden, not shifting the burden of proof, but just shifting to the appellant the burden of putting forth any reasonable explanation why she would have conveyed this home to him without having requested any money or anything other than that it was going to be the family marital home. Your Honors, the four elements are very clearly shown by substantial and competent evidence. In this particular case, we have a confidential relationship. Now, the appellant admits freely at pages 8 and 9 of its reply brief that there was a confidential relationship. But I don't want to leave it just at that, because it's more than just an admission on their part. We're talking about two individuals who lived together for 8 years, 6 years in this house. They were engaged to be married. Because of this confidential relationship, there was a requirement of stricter measures of candor. And in this case, as the judge appropriately found, there was
a requirement of stricter
measures of candor. Yes.
Because?
Well, because of the confidential relationship, and therefore when one party abuses that stricter measure of candor, then the presumption can arise that we spoke about.
And this arose because they were living together?
No, Your Honor. This arose because there was a confidential relationship, and it arose because of the other elements of constructive trust. It arose because there was a transfer of the property that was based on the promise to marry and to make that house the marital family home. And then the last element, of course, is the fact that there was unjust enrichment, and in this case there very clearly would be unjust enrichment if the appellant were to be permitted to partition this case. Number one, Ms. BIBONA contributed an upwards of $75,000 of her own money to purchase the property. She installed a dock. She added a pool. She made this home to her tastes and specifications. In addition, she fully intended to live in this home with her daughter, long term. And then she deeds it over to Mr. KUKETZ, not requesting any money from him, and for the stated purpose that it constitute the marital family home once they were married. They were scheduled to be married only 3 short months after the conveyance, so it's nearly simultaneous that the conveyance happens and the first marriage is supposed to take place.
So they established this relationship. Why isn't the remedy to allow him to get his money out of the house by either partition or allowing her to refinance, pay him, and then that way she's the person responsible for all of the debt and he can go about his merry way?
Well, in this case, Your Honor, the trial judge created or constructed the constructive trust based on equity grounds. It was a determination of the trial judge that, equitably speaking, this is the proper situation and scenario whereby we should rescind the deed and impose a constructive trust.
But why not one of the other options as recommended by the ALLAN?
Well, Your Honor, this case is much more than a simple case of rescission of a deed. It is much more than a case of simple partition.
I thought the purpose was to return the parties to the position they were in before.
That's correct, Your Honor, and that's
so if he gets his money back, what's the issue remaining?
Well, because a partition action would have forced the sale of this property, in which case, as I mentioned before with unjust enrichment, Ms. BIBONA would no longer have the property. She would be forced to sell the property, and the calculation of damages would be different.
Well, equitably speaking, should he still be on the mortgage and note?
Your Honor, at the time she conveyed the property to him and placed his name on the mortgage, she didn't need his name on the mortgage. To this day, she doesn't need him on the mortgage and doesn't want him on the mortgage. So if this court deems it appropriate to order the lower court to take him off the mortgage, of course that would be within Ms. Bibona's wishes. She does not want him to be tied to the property any longer.
So you would have no objection if this court took the position that, equitably speaking, the judge needs to enter an order requiring her to act in good faith to refinance and get him off the note and mortgage?
Well, I don't know that we're going to need to go as far as ordering her to refinance. I think that it is going to be just as simple as signing a document. But in the very least, just have him removed from the mortgage would be sufficient.
But if we say affirmed, your client doesn't have to do that. I mean, it would be voluntary.
I understand that.
So if we tell the trial court needs to include this order, I'm just asking if you have any objection to that.
We wouldn't have any objection to that, Your Honor. We, too, would like him to be removed from the mortgage.
Does the bank need to be consulted about just allowing somebody to be removed because they're not getting along anymore, and we think that it's okay with us?
Well, Your Honor, I believe that to be correct, and there have been steps taken since the final...
Is that in the record?
No, it's not in the
Then let's
record,
not
so
talk
I
about
really can't go there, but... the crux of appellant's argument is that there's not substantial competent evidence in this case. Your Honor, we submit that there is. I think what the appellant doesn't understand is that the trial court simply believed Ms. Bibona more than it believed him. And if I can cite now to the very final judgment and read to you a section from the final judgment, I think it demonstrates appropriately where the trial judge saw through the deception of the appellant. And I'm reading from page 6 of 16. At the top of the page, it's paragraph 11. And it reads, it's the third or fourth sentence in. It says, the parties set an initial wedding date of April 12, 2002. Shortly thereafter, the respondent indicated that he was getting cold feet and about getting married and wanted to seek the advice of a counselor. In November 2001, however, the respondent sent an email to petitioner requesting her to convey him an interest in her home. I think that it's the trial judge's use of the term however, which demonstrates that she fully understands the deception that was going on. I think that the court realized that Mr. KUKETZ's actions belied his words. On one hand, he is saying to her, I'm not really sure I want to get married, maybe we should go see counseling. At the same time, he's sending her an email saying to her, but, please make sure you sign this document deeding me over the property. In fact, if I can read the email is rather shocking to me. The email reads as follows, please print and sign a letter to me that because of my helping design this house, monthly rent payments, sharing every bill, putting sweat equity into 402 Lake Park Trail, in parentheses, and providing you a certain entertainment value through toys like Boat, Harley, and me, close parentheses, that except for your initial deposit of $40,000 with nominal interest, the rest of the equity in this house is split 50-50 between you and I. Your Honor, this is a fact that's in the record. This is a fact that the trial judge used to determine credibility, used to determine his intent to carry forward with the marriage and to make the family home their marital home. Let's take a look at who Mr. KUKETZ is and who it is that the trial court saw when he was sitting up there testifying. He's an intelligent, shrewd businessman who, by his own admission at page 353 of the trial transcript, now that's important because that wasn't in our brief, but he admits that he thoroughly enjoys buying and selling properties for investment purposes. At page 355, he admits that he actively looks for property for passive income or capital gain. Your Honors, what the trial judge saw when Mr. KUKETZ was testifying, and based on all of the evidence presented, was that he saw Ms. BIBONA and the house as yet another real estate investment. That contention, Your Honor, is further supported by fact number 20 in our brief, where during the summer of 2004, Mr. KUKETZ suggested that the parties sell the house in order to get their money out while the market was still good. Mr. KUKETZ did not have any emotional attachment to this home. This was merely a real estate investment, like his Castleberry home, like his Vermont condo. This was nothing more than a real estate investment from the beginning until the end. And, Your Honor, that leads me to a point that I'd like to stress in this case, is that here we are dealing with an abuse of confidence. By its very nature, we are dealing with secret, undisclosed intentions of the parties. Mr. KUKETZ doesn't want Ms. BIBONA to know that he really has no intention of moving forward with the marriage and making the home a marital family home. In such cases where there are secret, undisclosed intentions, they can often only be proved circumstantially by the subsequent actions and dealings of the parties. The entire premise of the appellant's argument is that this court should draw a line in the sand, an imaginary line in the sand, being August 2002, and say, you can't rely on any evidence past August 2002 to determine whether he has intent or not to do it. Whether he has intent not to do it, he is struggling to try and keep a secret. How else would anyone demonstrate that but by looking at a totality of the circumstances? And in this particular case, when you look at the final judgment, that is precisely what the court did. You can see recitations of facts that go all the way to November 2004, when the appellant forged Ms. BIBONA's signature in order to cancel the final wedding at Lou Gardens. I submit to you, Your Honors, that there is no case law to support appellant's contention that there should be an imaginary line drawn in the sand. You heard counsel say today that it should be quite obvious. That was their support for drawing this imaginary line in the sand. It simply doesn't exist and shouldn't happen in a case when you're dealing with abuse of confidence and deception. Moreover, Your Honors, the actions of the appellant after the conveyance also demonstrate credibility. Whether or not Mr. KUKETZ truly intended to marry Ms. BIBONA by giving her the engagement ring really becomes a question of credibility. It's simple, if you intend to engage in deception, to go and buy a $7,000 ring, not having the intention of going through with it, and then fight about getting it back later. To make a long story short, Your Honor, all of those facts post-August 2002 are essential in determining credibility and the intentions ultimately of Mr. KUKETZ.
Thank you, sir.
I'm not finished up, Your Honor, am I?
Excuse me?
Is my time over?
No, sir, you have 3 minutes, but 2.5, but you're repeating yourself.
Okay, then I'll move on. Your Honor, I didn't realize I was repeating myself, and I apologize. There are two aspects to this case. The first is the one raised by the appellant, and that is that there's no substantial competent evidence to show that there wasn't an intent to marry. There's an entirely different aspect to this case as well that is seminal to our argument, and that is that based on the accepted case law under constructive trust, it's not necessary that the court rely on whether he had the intention or not. And I'll cite to you two cases in particular, Brown v. Phillips and then the second is supporter versus supporter. In Brown versus Phillips, we have an 89-year-old man who owns 2 houses. He lives in one, and he rents out the other to the appellees in that case. The appellees approached this 89-year-old man and offered to pay to support him for the rest of his life if they convey to him the property that they live in. He did it. He conveyed him the house under the premise that they were going to provide him support for the rest of his life. Shortly after conveying the property, however, they listed the house for sale. The 89-year-old man came to the guys and said, "Hey, listen, I'm reminding you about the agreement that we had." And what happened was they simply stopped providing him meals, stopped providing him transportation, and stopped doing his laundry. They ultimately sold the house for $18,900. The Second District Court of Appeal held, in this case, the evidence adduced at trial is undisputed and uncontradicted that the promise of the appellees to take care of the appellant for the rest of his life was the primary consideration for his agreement to execute the deed in issue. It is well recognized as a proposition of law that the failure of a grantee to provide the agreed-to services of support during the grantor's lifetime, for which in whole or in part a deed was given, relates back to the inception of the contract and vitiates the entire agreement. The court went on to say that the conduct of the grantee, after accepting conveyance of the property, in failing to provide support and maintenance to the grantor, gives rise to the presumption of an abandonment of the contract and of a fraudulent intent in entering into it and taking conveyance of the property.
Thank you. You've exhausted all 20 of your minutes.
Thank you, Your Honor.
Thank you, Your Honors. Very briefly. Opposing counsel stood up here and admitted that there needed to be clear and convincing evidence, a very high standard, simply not here. He talks about deception and secrets, but, Your Honors, he omits talking about his own client's testimony. And Ms. BIBONA herself testified that Mr. KUKETZ was very candid with her. And the emails show that he was very candid with her. There was no untruthfulness or deception or secrets.
Are you asking us, in essence, to substitute our judgment and evaluation of what the judge heard for the judge who was there, had an opportunity to evaluate the witnesses, review the testimony of the experts called, the testimony of Dr. Tressler, and look at these documents, emails, refinancing?
There you are. First of all, Dr. Tressler has nothing to do with the issue that we're talking about.
I understand. My point is the judge was there and heard the witnesses.
Yes, Your Honor.
We did not.
I'm not asking you to reweigh the evidence. I'm asking you to find that the evidence was insufficient for the trial court judge to reach the conclusion she did, particularly considering the standard of proof. That's what I'm asking you to find. I'm also asking you to find that the law was misapplied here. Remember when we talked in my opening remarks, we talked about the law regarding undue influence and how the trial court judge mistakenly stated that law in her final judgment, mistakenly applied it. And do we hear any response from opposing counsel about that? No. The law was misapplied in this case, and we'd ask you to reverse. Thank you.
Thank you, ma'am.